Robert Courts.
Mr. Speaker, it's a pleasure to speak in this very, very important debate and to follow so many knowledgeable and impassioned speeches. And may I also join every other member in paying tribute to the honourable members for Rhondda and Halifax in having campaigned for so long in order to bring forward this bill, which I state at the outset I entirely support. I will in due course speak to some of the amendments. I wonder if I could just be permitted to say a few words in terms of general sport, simply because I haven't had the opportunity yet to address this matter. I simply would like to say, Madam Deputy Speaker is about to raise...
Order, order. The honourable gentleman has been very explicit in telling the House what he's about to say. He'd probably have got away with it if he just said it. But since he has been so explicit, and since we are in the dinner party of lawyers atmosphere, then I had better be careful and live up to the lawyer name as well. The honourable gentleman cannot be general at the moment. He can do that at third reading. But, of course, this group of amendments does cover an enormous range of matters, and I'm quite sure that he'll be in order in addressing those. Mr. Courts.
It's one of those situations where, as you quite rightly said, if I had simply said what I was intending to say, which was that we all owe a debt of gratitude to our emergency workers, both from the police and the ambulance service and everyone else, it's very important they have the full weight of the law behind them. We would perhaps have finished that aspect of my speech without me having pre-announced it. Having said that, one or two points I would like to make. Thank you. I do find there's some slightly odd elements in the drafting of this, which have been pre-shadowed by something some others have said already. And if I've understood the way that the bill is phrased at present, it does seem to me there are some anomalies which have been mentioned by the honourable member for North Poole and Mid Dorset. In that this is slightly unusual in its sentencing provisions, because normally, and I should say that I've, as has the honourable member for Cheltenham, prosecuted these offences and ones like them. It is slightly strange that you have the same sentence on indictment as you do on summary offences, because broadly put, for these either way offences, what everyone who is in the court facing all these offences has the ability to do is essentially to choose. They can have the quicker and relatively straightforward prospect of a trial, of a summary trial with a smaller sentence, a lesser sentence. Or they can go to the Crown Court with a jury, in which case they have the ability to have their case heard by a jury, but it takes longer. But the trade-off for that for them is that if they are then convicted, then they have the prospect of a greater sentence. So there is therefore an important tactical consideration for those who advise clients and for those who are defendants. The strange thing about this Act is it entirely removes that. As I understand it, there is little to compel anybody to opt for trial on a summary jurisdiction on the way the bill is drafted at the moment. Simply everybody would go for a trial by jury. Now that's fine in terms of the fact that the gold standard is trial by jury. It's something quite rightly we're very proud of in this country. But the difficulty is that there is a big backlog of these cases. The vast majority of cases in this country are dealt with on summary jurisdiction. And if we are encouraging people to opt for trial by jury, then we simply are increasing that. So I do have some difficulty with the way it's currently phrased and on the way that the bill is put. I do understand the reasons, of course, for the honourable member for Shipley's amendment, and I do understand the basis for the government, as I understand its opposition to those clauses, simply that it would be seen to be disproportionate in order to increase this maximum sentence by so much on indictment. But I do think, as the honourable member for North Dorset has said, that anomalous position really ought to be something that we consider, because it does seem to militate against that tactical concern that any lawyer will have when advising their client, because there's nothing to lose by going for a trial on indictment in front of a jury on the basis of this, which seems somewhat strange. It is also somewhat anomalous that we have, on the basis of this, a 12-month sentence on a magistrate's court when, absent the Section 154 of the Criminal Justice Act 2003 being brought into force, 6 months offences in most other cases for magistrates' offences. That is again somewhat odd. As I say, I support the bill, so I'm not seeking to take away from what it's seeking to achieve, but I do think those points ought to be made quite clear. Everything the bill is seeking to achieve in these circumstances is it's quite important that we are clear about what we're trying to achieve here. The Honourable Member for Cheltenham has made an excellent point. I would just like to emphasise that there is a danger that in this House we legislate for the sake of something being done. We have had innumerable criminal justice acts over the course of the last few years, and for those of us who've practised in the magistrates and in the Crown Courts, it can be very difficult to keep up to date with the latest criminal justice sentencing acts in particular, and as the guidelines keep changing. And there is a danger that when we're seeking to address a wrong, that we legislate in order to address that wrong, rather than simply to insist upon the correct charging decisions being made, which is the point that the Honourable Member for Cheltenham makes. I can understand that how is the point the Honourable Member for Halifax is being made, and there's no quick, easy answer to that. It's a matter of partly the criminal justice guidelines being toughened in appropriate circumstances, and also that the CPS work with their lawyers and train them in order to make sure that in circumstances the correct decision is made. It would be peculiar if, in the example given, a police officer's finger is bitten off, for that not to be charged as a GBH offence, which it clearly is. I understand from non-membership who says it wasn't. I'm not familiar with the background of the case. Maybe there was a good reason for it, maybe there was not. But I simply make the point that we need to be careful in this House not to complicate the statute book by seeking to introduce offences that cover every precise situation, rather than simply to use the more serious offences that already exist. And that again, that point is quite is also well made again with regards to the Sexual Offences Act, as of course the Honourable Member for Cheltenham has said. But I understand the basis behind this, because there is, and I don't object, and this is why I support the bill, because there are some cases when we simply do have to make clear, Madam Deputy Speaker, that a message must go out. That it is absolutely on this House's conscience and intention to make quite clear that emergency workers are protected. It's been a very long time, as the Honourable Member for Rhondda has said, since police officers who are assaulted in the course of their duty, they've been protected for some time, quite an elderly piece of legislation, as he says, and it's long since time that we extended that to those who work within the ambulance service in particular, and all other emergency workers. And I welcome the work that took place in committee in order to extend the definition that was there. Honourable Member, thank you.
I thank the Honourable Member for giving way. He's giving a very interesting and thought-provoking speech. Would agree, though, he's just said it's about sending out a message. Would agree with me, though, this is actually about giving prosecutors an extra tool in the box, a new offence, particularly enhanced with some of these amendments proposed today, particularly around spitting, that they can use to deal with this. It's not just about sending out a message, it's about giving them an actual tool to deal with it.
I entirely agree with the Honourable Member, and I'm grateful to him for making that absolutely clear. I was simply seeking to make clear that although in some cases there may be a greater sentencing offence that already exists, we still should have this one, because that sends a message. But in some cases, the Honourable Member is absolutely right. There isn't an offence that exists, and that is absolutely right that we address that. And I'd like just to conclude by making a few comments about spitting, which again the Honourable Member has a new clause to deal with, and I entirely agree with that. Spitting is a revolting act, and when I have prosecuted this and when I've defended innumerable times, I have seen, and it seems to become more prevalent over the last few years, that it seems to be something that is becoming more a part of people's behaviour when they're faced with emergency workers. It is disgusting, and people who work in the police force or the ambulance service, for example, ought not to have to put up with it. Quite right. But it's more important than that, because it is deliberately intended to cause worry. It is deliberately intended to add a psychological wound to a wound that otherwise is, relatively speaking, short-lived, because it's not a physical injury. It is absolutely right that we mark that, because there is no doubt that it causes immense distress, immense worry, and I've seen this firsthand on a number of occasions where those who work in the emergency services are understandably extremely distressed, long beyond the duration of a relatively short-lived incident, which takes place quite shortly. The worry about spitting and any contamination that may occur as a result of that goes on for weeks and sometimes months beyond that, and it's that we are seeking to address here, and it's for that reason I wholeheartedly support that amendment. Thank you.